Hello, dear students. Welcome to another audio session of CA Foundation Business Law with me, CA Preeti Aggarwal. In my previous lecture, I had explained the remaining elements of a valid contract, and in today's session, we are going to start with classification of contract. In today's session, we are going to discuss classification according to validity, and we will be covering void contract, voidable contract, illegal agreement. Both void and voidable contracts, they are important for exam, and we will be discussing all of them in detail. In case you have missed the earlier lectures, you can go through them on the Telegram channel. Also share these audio sessions with your friends and let maximum get the benefit of these audio notes. So let us begin today's session. We will discuss classification of contract. Now, contracts may be classified according to validity, enforceability, formation, or performance. According to validity, the contracts may be either void contract, voidable contract, or illegal agreement. We are going to discuss these three types of contracts today. Now, what is the meaning of void contract? But before we discuss that, what is the meaning of the word void? Void is not enforceable by law. It is the opposite of valid. So valid means enforceable by law. Void is not enforceable by law. They have used the word contract. It means that this was valid when entered, but later on, due to certain circumstances, the contract could not be enforced. It became a void contract. So the word void means not enforceable by law. It has no legal effect. It is a nullity. It is not a contract at all. This contract was valid when it was entered, but later on it became void due to certain circumstances. Like, say for example, A promised to marry B. Now the promise is a valid contract, but before marriage A died. Can we perform this contract now? No. The circumstance, that is death, has made the contract void. X promises to export onions to Y in Russia. So this is a valid contract when entered. But before export, the government imposed a ban on all export of onions. Can we now perform the contract? No. The contract becomes void. So void contract means the contract which was valid when it was entered, but later on it became void due to certain circumstances. What about maybe Y had given some advance? What about that advance? What about the benefit which was received by X? He could not perform the contract. Can he also keep the benefit with him? No, the benefit will have to be restored, and this is mentioned under section 65, which says that when a contract becomes void, party who has received the benefit or advantage must restore it. He must return it. So in case X had received some advance from Y, he will have to restore that advance because he could not export the onions, and it was not his fault. So Y cannot take any action on the grounds of breach of contract. Let us go through the definition as given under section 2 clause J of the Contract Act. Keep this in mind that we are discussing contracts which were valid when they were entered, but later on they became void due to certain circumstances. So let's keep that in mind and then read the definition. A contract means it was valid when entered, which ceases to be enforceable by law. Cease means it stops being enforceable by law. So a contract, it means it was valid when entered, but now it ceases to be enforceable by law. It stops being enforceable by law. Then what does it become? It becomes void. When does it become void? When it ceases to be enforceable. Okay, so a contract, it means it was valid when entered, which ceases to be enforceable by law, which stops being enforceable by law. What happens when it stops being enforceable by law? It becomes void. Now, when does it become void? When it ceases to be enforceable. Then we have void agreement. Now, agreement word shows that this is void right from the beginning. They are talking about void ab initio. Okay, so when the word used is agreement, it means they are talking about void ab initio. So some agreements are void or they are unenforceable right from the beginning. These agreements do not give rise to any legal consequence, and therefore they are unenforceable right from the beginning. They will never mature into a contract, like giving loan to a minor or entering into a contract for killing someone. This will never become a contract. Next, we have one very important concept, and many students get confused in this. It is voidable contract. Voidable, it means that these contracts are enforceable at the option of one party but not at the option of the other party. So an agreement this is defined under section 2 clause I. An agreement which is enforceable at the option of one party but not at the option of the other is a voidable contract. Now how will you understand this concept? Let's take the example of a Don. Okay, Don forced X to sell his house for rupees 1 lakh. So Don used coercion on X. Now the aggrieved party X has two options: either treat the contract as valid or cancel the contract. In case the contract is cancelled, he will restore the benefit. So when these options are available with the aggrieved party, then such contracts are known as voidable contracts. Please note, students, that these options are available only and only with the aggrieved party and not with the other party. So whether a contract should be treated as valid, whether it should be treated as enforceable or not, or whether it should be cancelled, these options are available with the aggrieved party, then such kind of contracts are known as voidable contracts. So the contract remains valid till it is rescinded. Contract must be cancelled within a reasonable time and benefit has to be restored. Now these options are available only with the aggrieved party and not the other party. Ma'am, how will we understand whether a contract is voidable or not? See, you can't choose that option on your own. Whether a contract is voidable or not will be given in the act. So up till now, you just remember that that contracts where the consent is obtained by coercion, undue influence, fraud, misrepresentation, they are voidable, and contracts where the consent is obtained by mistake is void. Now the option voidable will be selected only when it is mentioned in the act. So if you are very sure that the contract is voidable, it is given in the act, only then you will select this option in the exam. Otherwise you will only choose between valid and void contract. Alright, so let us read something about voidable contract. The contracts which are enforceable at the option of one party, that is the aggrieved party, but not at the option of other, then these are known as voidable contracts. Contracts where the consent is obtained by coercion, undue influence, fraud, misrepresentation, they are voidable, but where the consent is obtained by mistake, they are void. Now, why is a contract where the consent obtained by mistake is void, why not voidable? Now let's take the example of X offered to sell his horse to Y, but unknown to both the parties, the horse was already dead at the time of contract and both are not aware. Now if we consider this as a voidable contract, can the aggrieved party insist upon performance of the contract? Can he treat it as valid? No, the only option is to treat the contract as void, because you cannot sell a dead horse, you cannot perform the contract. That is why the contracts where consent is obtained by mistake will be void and not voidable. Okay, so there may be mistake of the existence of subject matter, there may be mistake of quantity. These agreements, they are void because you cannot perform them, they are caused as a result of mistake. Then the last kind of contract is it's not a contract, it's an agreement, it's an illegal agreement. Illegal is one which is contrary to law. Now illegal, what is the hint? How will you identify whether it is an illegal agreement? The word forbidden will be given in the question. So if the word forbidden is given in the question, it is a hint that they are talking about illegal agreement. Illegal means it is forbidden by law. You cannot enter into those contracts. Yes, so illegal is, it's just an agreement, it will not become a contract because enforceability is missing. These agreements are void ab initio. The collateral to an illegal will also be tainted with illegality, and the collateral will also become illegal. Okay, so these are the few points which you need to remember. How to identify illegal? It is very simple. The object will be unlawful, like killing, smuggling, drug dealing. These are all unlawful objects, and therefore the agreement will be an illegal agreement. So students, in today's session we discussed classification of contract on the basis of validity, void contract, voidable contract, and illegal agreement. In my next audio I will discuss classification according to enforceability and formation. So I'll see you in the next audio note. In case you wish to purchase the book, the compiler, podcast revision lectures, they are available on my website capreetiaggarwal.com. So do visit my website. And I will meet you with another audio session very soon.